This is Syndication Attorney Field Notes. I'm Tilden Moschetti, a syndication attorney, and today's field note is about the three-box entity structure in a Regulation D syndication. That's the sponsor entity, the investment entity, and the asset SPV. Here's how it usually starts. A sponsor sits down and asks me a simple question: can I just run the whole deal out of one LLC, one entity? One operating agreement, one set of filings? It feels cheaper, it feels cleaner. And in a Regulation D syndication, it is usually the wrong box. So let me give you the direct answer first. A scalable Reg D syndication is not one entity. It is three. The sponsor entity manages. The investment entity pools capital and issues the securities, and the asset SPV holds the property and absorbs its risk. Let me walk through those three boxes because each one has a different job. First, the sponsor entity. This is where your management team lives. Your general partners, your promoters, your track record. It holds no property. It takes no investor money. It's just the team and the management authority. And because your name and your track record live here, you can reuse this same box for Fund I, then Fund 2, then Fund 3. It's your management company, not a one-off deal vehicle. Second, the investment entity. This is the box that pools the LP capital. Think of it as the vault. It holds the cash and the equity. And this is the box that issues the securities in your private placement. Your investors are buying an interest in this entity. Third, the asset SPV. This is the box that holds the deed, holds the mortgage, and absorbs the property level risk. That's it. That's the whole job. No people, no capital pool, just title and liability. Now, why do smart sponsors get this wrong? A lot of the confusion comes from the venture capital world. Over there, the word SPV often means the whole pooled investment vehicle. And that works fine in venture because the asset is passive. A venture SPV buys shares in a startup. Those shares don't have a roof that can leak or a staircase a tenant can trip on. Real estate is different. Your asset is a building. It comes with physical liability. So the moment you copy that one box venture model, you've got a problem. You've put your investors' capital in the same box that can generate a lawsuit on its own. A slip and fall at the property names the entity that holds the deed. If that same entity holds the investor cash, the claim is now pointed straight at the capital pool. So don't use SPV as a nickname for your whole fund. In this structure, the SPV is the asset holding subsidiary at the bottom. It's a firewall, not the whole building. Now here's a distinction I want you to hold on to. The investment entity is the issuer, not the asset SPV when we talk about the offering documents, the PPM, the Form D, the subscription documents, those live at the investment entity level. That's what your investors are buying into. If you list the asset SPV as the issuer instead, you're basically telling your investors they own the property directly. And that quietly undoes the separation you were trying to build. Your LPs want to return. They don't want to be on the deed when something goes wrong. Keeping them one level above the asset is what keeps the limited in limited partner. Let me make this concrete with a quick example. Say you're building a fund to buy 3 apartment buildings. Here's how the 3 boxes line up. One sponsor entity manages the fund. Fund I is your investment entity. That's where the LP capital comes in. And Fund I owns 3 asset SPVs. SPV A holds property A, SPV B holds property B, SPV C holds property C. Now suppose property A has a contractor dispute or a lawsuit. The idea is that the problem stays at SPV A. It doesn't automatically reach across and freeze the capital sitting at the fund level, and it doesn't drag in property B or property C. Meanwhile, the rent and the sale proceeds flow up through the fund, and that's where distributions get paid. Authority flows down, cash flows up. Now, I want to be careful here because this is where sponsors overclaim. An SPV is a firewall, not a force field. Separate entities can reduce risk concentration. They do not make your assets untouchable. A few things to not assume. Don't assume the diagram protects you if you don't respect it. If you pay one entity's bills out of another entity's checking account, a court can decide the entities were never really separate because you treated them as one first. So separate bank accounts and clean books are part of the structure, not extra paperwork. Don't assume the entity stack neutralizes a personal guarantee. If you personally sign for the SPV's mortgage, the lender doesn't need to reach through anything. You already handed them access. Watch for bad boy carve-outs in your loan documents too. And don't assume you can copy one generic operating agreement across all three boxes. These documents have to reference each other. If the investment entity's operating agreement doesn't actually grant management authority to the sponsor entity, you've built the boxes and forgotten to connect them. So here's the field note to take with you. A scalable syndication isn't one thing wearing three hats. It's three jobs, and each job deserves its own box. The sponsor entity manages. The investment entity pools capital and issues the securities. The asset SPV holds the property and takes on its risk. Authority flows down, cash flows up, and the walls between the boxes are what keep one problem from becoming every problem. Before you launch your next capital raise, ask yourself one thing for every decision. Which box does this belong in? If you can answer that cleanly, your structure is doing its job. The longer written version of this is in the show notes. I'm Tilden Moschetti, and this has been Syndication Attorney Field Notes.